or disclaimer that I want to make is that what I'm doing today, this is part of my research that I'm doing as a visiting fellow at the Institute. And these are really quite undeveloped ideas that I'm trying to present in a rather developed way. So hopefully you'll bear that in mind as this presentation unfolds or unravels, more accurately. Now, the context and nature of this research, like I've said, it's not actually changed from that which was advertised, the abstract on the Institute's website. But what I'm doing in this research is trying to take a critical look at company law. And what I want to do today is really examine the ways in which company law and its institutions, and particularly its corporate governance techniques, constitutes and reinforce relations of domination and subordination in society. And I'll explain, hopefully that will all become clearer as I go on. I'll give you a little bit of background in the first quarter of this particular talk, to use corporate terminology. What are the fundamental, and this is really just trying to frame what I'm trying to say in this particular part of my research. One of the fundamental debates in law as a subject of social science concerns the nature and role of institutions in the operation of markets. Should financial institutions, such as mandatory legal rules, be deployed to govern economic activity, or, by contrast, should privately negotiated governance mechanisms prevail? And to turn to corporate governance, the field of corporate governance more specifically, how should corporate relationships be governed, through law or through contracts? So this is really the debate that just doesn't centre on corporate law. It's much broader within law itself. Now, on the one hand, you've got the idea of public ordering, or public order. And this is really very much focused on the role of the bureaucratic state in setting down what legal rules should be. Now, public ordering embodies a view of regulation, if we call it that, as a distinctly normative enterprise, rooted in the bureaucratic form of centralized state agencies. So the state is central to this particular paradigm. And it's realized the rules and norms and techniques used to govern relationships in society is realized via the medium of a formal set of jurisdictional claims or statutory pronouncements and judge-made law. Now, the opposing argument within this debate is the idea of private ordering, and that norms will form through some kind of emergent order without the involvement or the necessary interference of the state itself. Now, private ordering is defined as a mode of economic ordering that's largely private in nature, as the name suggests, and operates on the margins of formal institutions and legal frameworks. Now, it challenges, or private ordering challenges, state-centered conceptions of regulation as anachronistic, and for failing to really truly appreciate the extent to which governance is exercised through inter-organizational networks of private actors, and which relies less on formal arrangements from the state itself and more on informal arrangements through networks, through cooperation and bargaining and information leverage. And this produces, or this is produced through a series of bargains or exchanges through conflict and through cooperation by those participants involved in the given activity that's sought to be regulated, or is regulated from the bottom up. Now, this particular debate, certainly within corporate law, it really reached its, it seems to have reached its high watermark around the 1970s. And this was largely attributable to the law and economics movement, which was gained much more popularity, and still, I think, is much more popular in the United States. But about a decade later, in the 1980s, UK accents joined that chorus. And this was really where you saw law and economics imported into UK company law. And with that came a much more private view of the company, and this idea of private ordering, economic participants within the company bargaining with each other to create the rules and norms that will then govern the economic activity that they're involved in. This is really as a result of this importation of law and economics into UK company law. Now, and this is, I'm sure many of you know, is referred to as the Contractarian Thesis, or the Contractarian analysis of the company. And what it seeks to do is answer several doctrinal and normative questions, such as what is the company? How does it operate? What's the relationship between the company and the state and law and society? Now, like I've said, this is really a law and economics idea, and it's really based on the efficient markets hypothesis, the efficient markets hypothesis. Now, neoclassical economics, and especially its new institution economics branch, has provided this theoretical framework or basis for a regulatory model of governance by contract, rather than from positivistic mandatory legal rules. So private ordering really takes centre stage from the 1970s onwards, certainly within corporate law. Now, the first thing that this contractarian analysis of the company seeks to do is really, or the primary argument, first of all, is that the company as an entity, as a distinct thing, which has been recognised for well over a century, and some would even argue goes back to Roman times. For law and economics scholars writing this contractarian analysis of company law, the company really obscures the true economic reality of business activity. So as a result of that, the existence of the company as a distinct entity is disaggregated into simply a nexus for organising economic activity. Now, through this economic lens, intercorporate relationships are analogous to the dynamics of a macroeconomic exchange relationship elsewhere in a liberal market economy. So the company, so far as it does exist as a thing, acts as a microcosm for autonomous, rational economic actors, buyers and sellers, to engage in competitive and consensual interactions. And this is where bargaining really starts to commence. So each of these individual participants within this particular microcosm, what they're really doing is bringing with them resources, certain valuable resources. The company, if it does exist, acts as this microcosm to bring together people with financial wherewithal, people with human capital, people with management expertise, brings them together to exploit a particular business opportunity or idea in order to generate a positive expected value. But this is done through a series of bargains. And through these bargains, these actors, in essence, create or produce an emergent or a spontaneous order that governs the economic activity that they're involved in. Now, I want to emphasize this final point on this slide, because I think this is what, for me and for the purpose of this talk, is most important about law and economics and the Contractarian Thesis. And you'll find this particular assertion in the works of people like Jensen and Meckling and Alkin and Demsetz and Easterbrook and Fischel, that what the primary aspect of this bargaining relationship or nexus of bargaining relationships entails is a heterarchy, and by that I mean that everybody within the company is considered to be equals. They're competing and bargaining on a socially flat or economically flat basis. So that's the first assumption or key assumption that's explicitly recognized in numerous writings on the subject, that within this decentralized market community of individual actors bargaining with each other and a system of rules rising up from the bottom, we have this absence of hierarchy, that all participants are equal in that sense, and that they allocate risk and opportunity through voluntary cooperation and internal agreement. So there's a heterarchy, that they're socially and economically the same as each other, or at least no one's ranked in any preference. And secondly, that all these buyers and sellers within the company, they internally agree to the rules and norms that will govern the economic activity that they're involved in. These are two key assumptions that I want to kind of try and tackle. Now, before I do that though, like I've said already, according to the Law and Economics Thesis, or the Contractarian Claim, all the participants within the company are reduced to an equal non-hierarchical status within the company. Now, although contractarian proponents cannot argue that the company exists for the benefit of the shareholders because the company doesn't exist as a thing, these writers tend to arrive in a position that's not too far removed from shareholder primacy. And to explain how that's done, non-shareholders, as many of you already are aware, they are theoretically able to bargain ex ante for a specified share in the organisational rent, in the profits that are produced by the company. Now, the shareholders' bargain, however, is much more distinct and much more distinctly vulnerable than a non-shareholder. For the argument goes that the shareholder has a variable risk. They have no guaranteed return, only the right to residual profits, if the company does make profits, that is. So if the risk leads to the company to make additional profits, it belongs to her, the shareholder. But if the risk causes the company to lose money, it comes from the shareholder's profits. Therefore, the shareholder has, according to contractarian thinking, the shareholder has the greatest incentive to ensure that the board of directors maximizes the revenues, or at least acts in an efficient way to achieve that positive expected value on the company's exploitation of a particular business idea or opportunity, because the shareholders have the greatest risk to bear, so therefore they have the greatest incentive to monitor the board of directors to ensure they act efficiently and take the risks to achieve that positive expected value. I should also add here that shareholders or shareholder wealth is seen as a proxy for societal wealth, and that it's a default rule that everyone would agree to according to contractarian thinking if negotiation of this issue were possible. In other words, what's good for shareholder wealth is good for societal wealth. Now, this also explains fundamentally why the contractarian analysis extends to suggest that shareholders should be the party, the exclusive party, entitled to certain important control rights of the company to ensure that they can exercise oversight towards the board of directors to achieve that maximum or optimal positive expected value. So, moving on from the theory, the contractarian claim, I want to just quickly map onto Anglo-American law and practice how much this particular theory does really apply. In other words, does this contractarian claim adequately resemble Anglo-American corporate governance legal systems, corporate legal systems? Now, the first point, to ruin the surprise completely, I would suggest, I don't think I'm alone in suggesting this, that it's doubtful that contractual theory of the company really has any kind of universal explanatory value for US and indeed UK positive law. Turning to the United States first of all, I don't think this is particularly controversial to suggest that if contractual theory is representative of the United States of America, it's more representative of a state such as Delaware, where you've got a corporate charter that's more facilitative rather than mandatory, and it contains much more rules that can be opted out of compared to certain other US states that might have a greater presence of mandatory legal rules and less opting out within the bargains that are being struck within the company. Not only this geographical difference between state corporate laws, I think there's also a difference over time, historically, if you look at the UK corporate legal landscape, where the US has at certain points resembled more closely contractarian thinking rather than others. I think it's Lyman Johnson in the US who's argued that if Easterbrook and Fischel's contractarian writing really does have any prominence. It was probably the takeover movement that was prolific in the 1980s in America, and it doesn't really explain to such a great extent any of the decades that this idea has been popular. So that's also, I think, quite important to note, and I'd say the same for the UK as well, that every corporate governance system goes through cycles of greater regulation or greater state regulation and cycles of less state regulation, and that allows that space for private ordering, or arguably, some might suggest, allows that space for private ordering to really grow from the bottom up. But with the UK, although, like I've said, it's doubtful that the Contractarian claim applies universally, and there's certain times in history that it applies more so than others. With UK, I think it's very difficult to dispute that the UK, at the very least, has some contractual origins to its law. And in other words, there is some merit in applying the Contractarian claim to UK corporate law, company law, whether that's in the corporate contract, the constitution that every company has to have, or something like Section 33 of the Companies Act 2006 that binds the parties to that constitution. And there are other facets too that really do lend itself to the idea that UK company law at least has some fundamental aspects that resemble Contractarian thinking by the law and economics people. But I think mostly in this deregulatory era, during the process of globalization and neoliberalism that's taken place over the past few decades, since the 1970s onwards, Contractarian analysis has become much, I think, most influential, especially in academia and also in policy debates. And this is why we can't ignore it in this UK context. Although it's an idea that originates in the United States and probably applies more in the United States, certainly, like I've said, there are elements, fundamental elements of Contractarian thinking in the law itself. And academics, certainly, we take it quite seriously. Although not a particular recent quote, Michael Wincott was talking about corporate law in the common law world more generally, but this included the UK as well. Michael Wincott in 1999 said that Contractarian theory is inevitable because of the contractual qualities of the company. So there you've got the theory or the paradigm becoming a real bastion of corporate legal academia in the UK. And it's also been highly influential as a theory to explain how the company works and its relationship with society and the law more generally. Because the Law Commission and the Company Law Review Steering Group have both quite significantly and substantially considered these contractual views of the company. So, it's certainly something that we have to take note of. Now, this is where I want to take a break from what you probably already know already, and use this as a point of departure to take this argument in a new direction. And this is where I'm on particularly shaky ground. Now, despite the significance, despite significant and sustained treatment for several decades now of this contractual model of the company, it remains, I think, situated in a theoretical framework. And too much intellectual effort, I would argue, has been devoted to abstract description or explicitly normative writing, while not enough has gone into empirical investigation of the physical or concrete experiences of how private systems of rules work to regulate those socio-economic relations among the groups that adopt those norms and rules. There are a number of paradigm cases that haven't really been brought into corporate legal scholarship in the US or even in the UK that do lend themselves to giving some intriguing insights into how private ordering works as a system of regulating any kind of social or economic activity. And this is the neglected empirical evidence that I want to talk about for the next 15 or 20 minutes. The first one is it refers to a case study, and most of these were done around about the time of in the 1990s. An academic called Lisa Bernstein produced the first case study, and this was about focusing on the Diamond Dealers Club, a certain district, a Jewish community within New York that was purported to have or govern itself by adopting a private system of norms and culture and rules, and trying to eschew any kind of rule for the state itself. There are a few more examples, but the second one I want to talk about, because of time constraints, is these rancher-farmer relations in a place called Shasta County, California. Now these, particularly these two case studies, the second one, by the way, the rancher-farmer relations, was by a guy called Robert Ellickson, again in the 1990s. And this was a piece of research, empirical research, that was really based on a certain bit of writing that I think Ronald Coase did many, many decades ago. And what Robert Ellickson tried to do was really explore this claim empirically. So that's the second seminal case study I want to talk about. But these prototype cases of private ordering are purported to highlight how participants have devised and adopted private order systems to govern the socio-economic relations that are said to govern how they operate in daily life. But like I've said, there's, I think, two important insights that this neglected empirical evidence supplies us with that we can then take back to this contractarian private ordering theory of company law. The first one relates to hierarchy in private ordering. You remember already that I've said that many of the works in law and economics writing on contractarian or the contractarian nature of the company suggest that relations within that company are a heterarchy, that they are socially economic flat, there's no presence of a hierarchy. These case studies dispute that point. A close reading of the paradigm cases suggests there is a correlation between private orders and hierarchical socio-economic structure. Moreover, this reading suggests that there's also a relationship of causation between private orders and hierarchy. I'm not trying to suggest that every single community that governs itself through private ordering involves a relation of correlation, the presence of correlation and causation, but certainly many of these, and certainly all of the case studies that I've looked at here, involve this relationship, this correlative and causal relationship between a hierarchy that exists in the first place and then the development, the bottom-up growth of these norms and rules that we'd say is private ordering. Now, this hierarchical structure, based on the case studies that I've looked at, and I'll explain in more detail what I mean by this. This hierarchical structure provides power holders, those at the top of the structure, with an incentive to create private orders that allow them to sustain the norms that preserve the power structure that they benefit from. Equally, and by contrast, these hierarchies provide incentives to lower-ranking group members. Incentives to lower-ranking group members who are embedded in this particular structure. They become locked into this private ordering system in such a way that they are prevented from dissenting or exiting. And they have to use this private order or these private orders, even when their decisions and norms work against these lower-ranking group members' interests. Now, as a result, private orders, it would seem, do not function in a manner that's predicted by traditional law and economics analysis, and instead of performing a power balancing function, which ensures a certain degree of allocative efficiency, it tends to exacerbate power influence, power imbalances and allocational problems in a continual movement away from the desired equilibrium. Now, this, like I've said, really places private order in conflict with autonomy or the freedom or the heterarchy that is suggested in law and economic scholarship on company law. The second insight that we can gather from these case studies is that law and economics literature tends to suggest, or at least ascribe, a passive role, if any, to the state when it comes to the development of private ordering. Now, when the literature does acknowledge, and it does acknowledge the involvement of some kind of sovereign authority or state interference in private ordering, it focuses mainly on the state's emissions, which ostensibly lead to the development, or we are told lead to the development of private ordering. Now, this second claim that's posited is that the public order, the state itself, which is meant to be kept out of private ordering, is actually intentionally active, indeed activist, in creating private orders. In other words, not all private orders can't exist without state intervention, but fundamentally, the state plays a very important role in, at the very least, acknowledging that private orders exist. But in certain situations, you can see from some of these paradigm case studies that the state will actually impose certain rules or structures on a society that will lead that society to adopt a system of private ordering with norms and cultures and rules that will govern their social or economic activity, even when they don't necessarily want to govern themselves by private ordering. So, the first of these case studies involves the Diamond Dealers Club in New York by Lisa Bernstein. And this was the New York Jewish community around about the time of I think the 1920s. And they actually had a relatively sophisticated arbitration system based, like I said, around the kind of time of the 1920s. And they had quite a sophisticated arbitration system, and this depended on that particular Jewish community within New York and its institutions for the enforcement of the rules and cultures and norms that were predicated within that particular socio-economic circle. Now, the reason why this arbitration system developed from the bottom up in this area of New York was a response to the 1917 Russian pogroms, where you had various different Jewish people that were kind of having to leave Eastern Europe and parts of Russia and having to kind of make a new life elsewhere, and many of them came to, particularly New York in this case. Now, prominent members, and this is the power holders within this hierarchy, prominent members of the Jewish community, they were worried about the immigrants' impact on the community's hitherto good standing, a reputation that was central to the members' ability to integrate and prosper socially but also economically. So as a result, a couple of Jewish lawyers decided to establish this Jewish court of arbitration to settle disputes internally within a private framework and a complete, or what was seen to be a complete rejection of the state. Interestingly, and this is where the state plays a crucial role in the development of private orders, the reason why this Jewish court of arbitration was possible was because of a piece of legislation that was enacted in New York shortly afterwards. It had been in the pipeline for a while, but enacted shortly after this arbitration court was developed. New York, as a state, passed this piece of legislation that allowed private mediation to have a binding effect if it was taken to a proper court of law. So this is really the facilitation of people, or pushing people to resolve their disputes or allocate resources and assets internally without reference to the legal system. But it was created, one might argue, by the state passing that piece of legislation. Now, within this Jewish court of arbitration, set up by the prominent members of the Jewish community, worried about the effect that the immigrants having on the standing of the Jewish community in New York, there was a clear socio-economic gap between the Jewish Court of Arbitration's mediators, who were comprised of rabbis, doctors, lawyers, particularly affluent members of that community, who all volunteered their time, and on the other hand, the parties that were appearing or pushed into this mediation, who were Eastern European immigrants, often coming from the more impoverished parts of New York on the Lower East Side, which is now really quite trendy, I think, but at that time it was quite an impoverished area of New York. And so it was a way, in essence, of pushing these new settlers into this private form of dispute resolution. And it was the power holders, the more influential, affluent members of that community that were really devising this system of norms and rules to ensure that these disputes were settled according to that hierarchy. Now, this hierarchy embedded in economic and religious dependency, because not only was the hierarchy based on one's economic standing or social standing with the community, it was also emphasizing religious standing within the community. And typically those Jewish Court of Arbitration panel members were those ones that were more senior in the religion itself. So this hierarchy embedded in economic and religious dependency plays a triple role in the creation of private ordering within the Jewish community around this time of the 1920s. First of all, what this hierarchy does is incentivizes, on the one hand, and discourages avoidance of public courts. So these poorer Eastern European immigrants that were pushed into using this particular Jewish Court of Arbitration to settle their differences within the community. And it could be about anything from defamation to slightly more serious issues of who has ownership of a particular good or non-payment of particular services and so on. These less affluent members were incentivized to use this form of private rulemaking or private redress because the Jewish Court of Arbitration, in the first instance, it was free as opposed to the public courts, which were more costly. Secondly, the Jewish Court of Arbitration was conducted in the individual plaintiff or defendant's own language, so it made it much more accessible. But I think most importantly, the incentives to individuals, these lower-ranking group members, to use this private system of redress that was based on hierarchy was because senior members of this hierarchy, those particularly sitting as panel members within this Jewish Court of Arbitration, prominent members of the community, influential, had access, had capital, they would often ensure these less affluent members having their cases heard by the Jewish Court of Arbitration had access to themselves, so that it was not uncommon, or it's not uncommon for these higher-ranking members to spend more time after the formal proceedings finished working through the problems with the lower-ranking group members, providing them access to more influential people. Employment is sometimes offered. Finance is sometimes offered by the senior members towards the lower members, again, all to keep these claims behind closed doors to save embarrassment being brought on the Jewish community. That's the incentive, but there was also, like I've said, there was also discouragement from using public courts, and still is, where, for example, any members that choose not to use this Jewish Court of Arbitration and go to the public courts to settle a dispute that would therefore bring into the public eye what was meant to be kept private, people could be excluded from their communities, which doesn't sound much to you or I. We'd probably quite happily live somewhere else if we were told to leave London or wherever it is we live. But these Eastern European immigrants were often unable to speak English, and if you were and depended fundamentally on their community for jobs and religion and social activities. If you were excluded from your community, it was incredibly difficult to make a life for yourself in this new country. Also, you could have the withdrawal of religious goods. So there's certain ceremonies within that Jewish faith that you would then not be able to attend, and so on. And there's stories about people having, in essence, a withdrawal of the opportunity to marry because shame was brought on their family because they're excluded, and as a result, nobody would want to marry them because the family was then tarnished as well. Another way in which hierarchy plays a key role in this particular socioeconomic structure is a series, what it does is serves as an enforcement device for dispute resolution decisions of private ordering. And thirdly, this hierarchy produces a clear, I think this is an important point, Hierarchy produces a clear normative value ranking, without which effective informal sanctioning would be impossible. And within this private ordering framework, informal sanctioning and norms were very important, or still are very important. Now, you might wonder why I'm talking about the Jewish Court of Arbitration when this is referring to the Diamond Dealers Club in New York. There is a good reason. The New York Diamond Dealers Club came after this particular establishment of a private order system of norms and rules. And it depended fundamentally on this existing culture of private ordering within that Jewish community. So the New York Diamond Dealers Club had an arbitration committee that was created after this Jewish Court of Arbitration. It exists and still continues to exist because the diamond merchants are not only a profit-oriented community, but also they're part of this larger private ordering framework that I've just been discussing. And as such, the Diamond Dealers Club of New York depends crucially on that community and that system of private ordering. And its institutions, I should add, for enforcement and for population screening. In other words, it's part, or this Diamond Dealers Club Arbitration Committee, is part of an extra legal community that utilizes class-based and religious hierarchies to regulate itself. So, like I've said, the Jewish Court of Arbitration that established this private ordering system, and then later you have the Diamond Dealers Club of New York that depends fundamentally on this existing framework of how people deal with each other when they have disputes in a social or economic relationship within that Jewish community of New York. So what's quite often the case with the Diamond Dealers Club, many disputes resolve or center on defamation. So one particular diamond merchant might have a rumor going around that their diamonds aren't genuine, or they're lower grade than what they're represented to be. So those disputes again can be settled in-house using that private system, that hierarchy. And there's also evidence not done by Lisa Bernstein, but by a couple of other authors, that also suggests that if this is a commercial hearing, to call it that, a hearing, if this is a commercial hearing, it's more likely to be brought by someone who's a business person, and therefore they've got a more elevated standing within that community, and the actual Diamond Dealers Club Arbitration Committee take those types of cases more seriously than someone, and this actually is based on another case study, just an ordinary member of that Jewish community, a recent settler, who'd also had gossip or rumors spread about them and brought an action of defamation within this private community, of the system of norms and practices. And the court had no time for this ordinary person saying that they should know better, and they were almost scolded by the mediators, suggesting that no one sensible would take any heed of such rumors. But if it was a commercial person who was higher up in the hierarchy, their claim was taken much more seriously. So again, that's the key role of hierarchy within this particular system of private ordering. Another interesting one is Shasta County in California. Now this study refers to the results of an investigation into the rural, or into how rural landowners resolve disputes amongst themselves over livestock trespassing onto each other's land. Now there's three key groups within this particular community. The first one is ranchers, or traditional ranchers, the kind of guys that sleep out under the stars and probably sit around a campfire and idolize John Wayne, and they let their cattle roam. And this Shasta County, by the way, really I'm simplifying this terribly crudely. If anyone is from Shasta County here, which is highly unlikely, don't scare me. It's just it's a very rural area, it's quite mountainous, and it's really predominantly used for cattle grazing. Because of different weather conditions changing throughout the year, then the cattle have to roam in different places. Now these traditional ranchers will sleep out under the stars and let their cattle roam wherever. And they've got very traditional ways. Now, often these traditional ranchers are land rich. They own lots of land, but they make very little money from the cattle. And if they do want to make a bit of money, they often just sell off bits of their land. There are also the modernist ranchers, who are typically younger, slightly more educated, and they keep their cattle fenced in. They don't let them roam wherever they want across Shasta County. They keep them fenced in. But their fates are entwined, because the land that's being sold off by the traditionally ranchers to raise a bit of cash from time to time is now going to a third group, these newer ranchette owners, who tend to be retirees or younger people from the surrounding metropolitan area in California, who've moved to Shasta County and tend to be kind of situated at the bottom of the mountains and have a relatively small 2 or 3 acre piece of land. And these are really the weakest member within the hierarchy of this so-called private ordering system. First of all, much of the land in Shasta County is what's called open range, which means that cattle can roam anywhere, and there is no public interference in that. But there are certain parts of Shasta County which are now becoming, or have become closed range, which means that any cattle that wander or stray onto those closed range areas, the owners of the cattle are liable for any kind of penalty and damage that the cattle might cause. So as a result, traditionalist and modernist ranchers are both opposed to the idea of the state or the county closing the range. Even though the modernist ranchers keep their cattle penned in, some can escape, and so therefore they oppose any kind of interference from the outside, from the public order, in closing the range. In fact, there was a funny little anecdote. I say it's funny, I'm stretching the term very much there, but this board, there's a board in Shasta County that decides, and this is the state, if you like, a board in Shasta County that decides whether land is closed or closed range or open range. And one of the few places that's closed range in Shasta County, the main chairperson of that board now has their name linked with this closed range. It's named something like Smith's Folly, because the ranchers wanted to embarrass the actual public official that decided to close the range and increase the liability of the ranchers from their cattle straying. So both traditionalist and modernist ranchers are opposed to any kind of interference by the public order, by this county, these county officials. Now, the problem is, these newer ranchers, the retirees and the younger people from the metropolitan areas, what do they do when cattle stray onto their land? And often it's causing quite a bit of damage. If they approach, according to Robert Erickson's study, if they approached members of the Shasta County board to try and close certain parts of the range, they were told to settle their disputes internally, because respect of norms and cultures that have been established over generations in Shasta County were told to be observed, and that they took prominence over the interference of the Shasta County authorities. If these ranchette owners approached the police, the local county sheriff, again, a blind eye was turned to any damage that was caused to their property. The only option was really to try and settle their dispute internally, and this is how the private order system developed in Shasta County. The problem is that the rancher owners, whenever they tried to resolve their disputes with the modernist and the traditionalist ranchers, they had very little influence. They are the weakest members of the community. The traditionalists and mostly the modernist ranchers are incredibly politically powerful. They've got symbolic status within that community, and they also have the wealth. So they are the powerful members that have locked the weaker rancher owners into this hierarchical structure to try and settle their disputes in a private way. So really, the traditional ranchers and the modernist ranchers are very much the ruling elite within this particular framework of norms and cultures that govern the activity between these participants. So, what I would say here is that That diagram there, I just wanted a diagram basically, but it's not really representative of what I'm trying to say here. If we try and map what I'm saying, when we look at these neglected empirical case studies, and map them onto corporate relations, the relations between shareholders or the employees or the environment, creditors within the company that's said to involve private ordering, these two central insights really show us, I think, that the state, first of all, is very active in the creation and maintenance of these private orders. But secondly, there's the presence of hierarchy, which, like I've said, has that correlative and cause and influence on the development and growth of private orders that's said, or I think exists within certain fundamental aspects of UK company law. So these empirical case studies, I think, tell us that intra-corporate relations are more likely to be vertical. This is why the diagram is a little bit misleading. But there was no diagram to match that. More likely to be vertical rather than horizontal, socially flat heterarchies that are suggested in the law and economics literature. And it seems clear, or at least arguable, that the shareholders within the company are at least the beneficiary of this preferential governance status within the private ordering dynamics of company law. So just to kind of skirt very quickly over this, shareholders are, as the most prominent and powerful members within this hierarchy within corporate relations, they are the key beneficiary, I think, of takeover regulation, or at least protected and entitled to a great deal of leeway within takeover regulation in the UK. They are the subject of directors' duties, or majority of directors' duties, at least meaningful behavioural obligations set for directors. Shareholders also have this ex post rights of enforcement through derivative action and so on that doesn't belong to any of the participants within that hierarchy of corporate relations. Shareholders also have limited liability, unlike any other particular constituent or participant in corporate activity. And mostly, shareholders have very important or certain important and unremitting decision-making rights within the company that's, I think, really does push them towards the top of that hierarchy out of all those participants. So just to kind of sum up, and many of you will probably breathe a sigh of relief as I do this. Like I've said already, I think in the UK, although the contractarian private ordering view of company law doesn't explain universally UK company law, there are certain fundamental aspects of UK company law that do seem to resemble this private ordering thesis. Central to that claim is that the participants are involved in a heterarchy. In other words, they're unranked. They could be ranked in any given way, but they're not ranked. And that each participant, when they buy or sell goods within this microcosm of economic activity that is the company, they're agreeing. They all agree. And that's how these norms and cultures arise from the bottom up. But these paradigm case studies, I think, provide these two insights that, first of all, like I've said, the state is incredibly important to private orders. Contrary to what much of the literature suggests, private orders don't just simply grow in the space where the state doesn't exist. The state is active and indeed activist in the creation or at least acknowledgement of private ordering. But mostly private orders are so closely linked to hierarchies. And I think that's the key thing to take from this particular talk. That the lower ranking group members within any private order, but particularly in this context within the company, they're subject to this twin reality of domination by the state, and secondly by the powerful or more powerful ranking members within that hierarchy of company relations.